Question number 126. The expression justice, social, economic and political appears in, it is a very easy question, it appears in the preamble of the Constitution of India. Question number 127. A Hindu who is separated from his father B sells to C 3 houses X, Y and Z, representing that A was authorized to transfer the same. Y, however, does not belong to A, it having been retained by B on partition, but on B's dying, A as heir obtains Y. Here, can C file a suit requiring A to deliver Y to him? Options are yes, if the contract still subsists; B, only if A was the authorized owner of Y at the time of entering into the agreement to sell with C; third, only if A has not leased out the property; and four, none of the above. In this question, the correct answer is option number first, yes, if the contract still subsists. Match the columns to identify what passes along with the transfer of a certain kind of property. Option A, machinery attached to earth. Option B, debt or other actionable claim. Option C, money. And option D, house. Here, the first option, machinery attached to earth, comes in the category of movable parts thereof. Option 2, debt or other actionable claim, it comes in the part of securities. Money is related to interest, and house, easement annexed therewith. Question number 129. A fraudulently informs B that A's house is free from encumbrance. B thereupon buys the house. The house is subjected to mortgage. The contract is voidable at the option of B, voidable at the option of either A or B, impossible to perform. The contract will be voidable from the option of B. The first option is the correct answer. Question number 130. The shopkeeper has displayed his goods in glass showcase with the price tag prominently visible. B identifies an item from the showcase for purchase and tells A that he is ready to give the price displayed. A realizes that the item did not have the correct price tag and refuses to sell it at the displayed price. Give the most appropriate answer. Options are A is bound to sell the item as all conditions of a valid contract are complete. Option second, A is not bound to sell B, has only made an offer to purchase and A has still to accept the offer. And option 3, A is bound to sell as his display of goods in the showcase amounted to offer to sell. And option 4, A is not bound to sell though acceptance was complete. Here the correct answer is option A is not bound to sell as B has only made an offer to purchase and A has still to accept the offer. Question number 131. Whether the consideration under a contract for the contract to be valid can only be exchanged between the parties to the contract and not by or between third person who are not parties to the contract. Option R, consideration can be paid even by third party to a contract. Consideration to a contract cannot be paid by a third party to the contract except when payment is by negotiable instrument. Consideration can be exchanged between third parties to contract but only when third parties are legal heirs of the original parties to the contract. Option 4, consideration can be exchanged between persons who are not parties to the contract if at least some part of the consideration is received between the parties to the contract. In this question, the correct answer is option first, consideration can be paid even by third party to a contract. This is provided from the definition of consideration in Indian Contract Act. Question number 132. Whether a contract in which time for performance of an obligation is not specified is a valid contract. Options are contract will be void as there is no consensus ad idem as to the time for the performance of the obligation vide section 10 of the Indian Contract Act. Option 2, even if time is not fixed, law will presume that the obligation has to be performed in a reasonable time as provided by section 46 of the Indian Contract Act. Option 3, even if no time period is provided by the contract for performance of an obligation, the contract is valid if it is recorded into registered document. And option 4, even if no time for performance is provided, it is a valid contract provided that the contract is a non-commercial contract only. Question 132, the correct answer is option second. Even if time is not fixed, law will presume that the obligation has to be performed in a reasonable time as provided by the section 46 of the Indian Contract Act. Question number 133. By a contract, there are two sets of promise, with one set of promise being legal and the other set of promises being illegal. In view of the statement, which of the following is correct? Here the correct answer is there can be such a contract, but the contract will only be for the legal set and not for the illegal set of promise, vide section 57 and 58 of the Indian Contract Act. This is the correct answer because only the legal part will come into effect and the illegal part of the contract will not come into the effect because of the section 57 and 58 of the Indian contract. Now we will move on to question number 134. A woman cannot be arrested or detained in civil prison in execution of a money decree. Is this a correct statement? Option 1, yes, there is a general rule that a woman cannot be arrested or detained in a civil prison in execution of a money decree. This option is only the right option. There is a general rule in CPC that a woman cannot be arrested or detained in a civil prison in execution of a money decree. Now let us move on to question number 135. Question number 135. A judgment debtor is arrested in execution of a money decree. Will he be discharged from the debt under the concerned money decree on completion of the period of detention? Option 1, no, even on release after undergoing the period of detention, he will still be liable for the payment of the money decree in view of section 58 of CPC. Option 2, yes, he will be discharged from the debt under the concerned money decree. Option 3, yes, he will be discharged from debt if the money decree is less than rupees 1 lakh. And option 4, yes, he will be discharged from the debt even if the decree pertains to the recovery of loan. Here the correct answer is option 1. No, even on the release after undergoing period of detention, he will still be liable for payment under the money decree in view of section 58 of CPC. Section 58 clause 2 of CPC clears that a judgment debtor released from the detention under this section shall not merely by reason of his release be discharged from his debt, but he shall not be liable to be re-arrested under the decree in execution of which he was detained in civil prison. Now let us move to question number 136. Can a person who has not suffered special damage because of public nuisance or wrongful act affecting the public file a suit? Option 1, absolutely not. Option 2, yes, provided a plaint is filed by 2 or more persons and deed the court is obtained. Option 3, yes, because everyone is a member of the public and can espouse grievance and seek appropriate relief under section 38 of the Specific Relief Act. Option 4, yes, only if the plaintiff seeks approval and is granted sanction by the Advocate General of the state. Here the question is asked, can a person who has not suffered special damage because of public nuisance or wrongful act affecting the public file a suit? Correct answer for this is option 2, yes, provided that a plaint is filed by 2 or more persons and leave of the court is obtained. Now let us move to the question number 137. Where a suit plaint seeking relief of possession of an immovable property is rejected under Order 7, Rule 11 CPC, whether filing of a fresh suit is barred? Options are no, filing of a suit is not barred provided fresh suit is filed within the period of limitation. This very option is the correct option for question number 137. This is the right answer. Question number 138. Can a court pass a decree in suit seeking rights in an immovable property where a defendant has transferred his interest and rights in the suit property to a third person without issue of summons or notice to the third person? If yes, whether the decree will be binding against the transferee pendent light? Options are no, notice must be issued to the third person, otherwise decree would not be binding on him. Option 2, decree without notice to a third person is valid and notice summons is not required to be issued to the third person. Option 3, decree will be invalid as it violates principles of natural justice. And option 4, decree will be invalid as a judgment. It is only binding on the parties to the suit and doctrine in personam applies. Correct answer for question number 138 is option 2, decree without notice to third person is valid and notice or summons is not required to be issued to the third person. This is the right answer. Question number 139. Which of the following is not correct regarding section 6 of the SRA? Option 1, the period of limitation for filing suit thereunder is 6 months. Option 2, no suits against the government can be brought under the said section. Option 3, the order or decree passed under the said section is immune from challenge by appeal as well as by review. And option 4, it would be necessary for the plaintiff in such a case to prove the absolute title to the property. Here the correct answer is option 4 because it has been asked, which is not correct. This statement is not correct, hence it is the correct answer. Other statements are correct. Which of the following proposition is not correct? The plaintiff is entitled to seek a decree for specific performance of contract or compensation in lieu of specific performance under the Specific Relief Act. If liquidated damages have been provided, the plaintiff cannot seek specific performance. Option 3, the court may grant possession, partition or separate possession to the plaintiff in addition to the specific performance of the contract. Option 4, the court may direct refund of the earnest money or deposit made if a specific performance is refused. For question number 140, the correct answer is the second option. If liquidated damages have been provided, the plaintiff cannot seek specific performance. This is the right answer. Now let us move on to the question number 141. A suit for possession of an immovable property based on title by a plaintiff who has been dispossessed can be filed. Option 1, within 6 months of the dispossession as per section 5 of the Specific Relief Act. Option 2, even beyond 6 months and up to period of 12 years as provided in the Article 65 of the Limitation Act when dispossession is of a person who is the title holder of the immovable property. This is the right answer. Related to a suit for possession of an immovable property based on the title by a plaintiff who has been dispossessed can be filed even beyond 6 months and up to 12 years as provided in Article 65 of the Limitation Act when dispossession is of a person who is the title holder of the immovable property. This option is the correct answer. Now let us move to the question number 142. Whether a specific performance of an earlier agreement to sell an immovable property can be granted against a person who has subsequently purchased the subject property. Options are no. Once the immovable property, which is the subject matter of an agreement to sell, is sold by the seller to the third person, the earlier agreement to sell is frustrated. Option 2, a proposed buyer under an agreement to sell can seek a specific performance of a contract to sell an immovable property even if the subsequent purchaser is a purchaser for the value but with notice of the prior agreement to sell. Option 3, only if immovable property, which is the subject matter of an agreement to sell, is transferred during the pendency of the suit and not before filing of the suit. And option 4, a proposed purchaser under agreement to sell can file a suit against the subsequent purchaser of the property, which is the subject matter of the prior agreement to sell, but only if payment is made by the proposed purchaser by means of check or bank draft. And question number 42, correct answer is option 2, a proposed buyer under an agreement to sell can seek a specific performance of a contract to sell an immovable property even if the subsequent purchaser is a purchaser for value but with notice of the prior agreement to sell. Now let us move on to the question number 143. Can a suit for declaration be filed without seeking any further relief, although such further relief is available to plaintiff? Options are yes, a suit simply seeking the relief of declaration can be filed without seeking further relief if the plaintiff is a pauper and does not have financial means to pay the court fees for the further relief in addition to the relief declaration. Option 2, no, the plaintiff is bound to file a suit for declaration and seek further relief once the further relief is available being claimed in the suit for declaration which is filed. Option 3, yes, if the consequential relief is claimed in another suit would not be barred under the law of limitation. And option 4, a suit for declaration without seeking further relief can be filed. Correct answer is option 2, no, plaintiff is bound to file a suit for declaration and seek further relief once the further relief is available for being claimed in the suit for declaration which is filed. This is the right answer. Question number 144. Select the correct statement. A suit can be filed to enforce a negative covenant contained in an agreement even if the specific performance cannot be granted, provided that the plaintiff has not failed to perform all his obligations under the agreement. This statement is the correct statement. We have to find a correct statement over here, and this statement, the option first, is the correct statement. So this is the right answer. Now let us move on to the question number 145. Read the following statement. There is a rebuttable presumption that a check bearing a date was made or drawn on such date. It cannot be presumed that the holder of a check is a holder in due course. Option 3, there is an irrebuttable presumption that the check was made or drawn for consideration. Select the correct answer. Options are all three of the statements are correct. Option 2, only first statement is correct. Option 3, the first and the second statement are correct. And option 4, none of the above. Here only first statement is correct, so the option 2 is the right answer, that there is a rebuttable presumption that the check bearing a date was made or drawn on such date. Now let us move on to question number 146. For cognizance to be taken on the offence of dishonor of check for insufficiency of funds in the account, which of the following are prerequisites? The check must have been presented to the bank within the period of its validity or within 6 months from the date on which it was drawn, whichever is earlier. This statement is the correct statement. Second option, the complaint must prove by independent evidence that the check was issued for discharge of debt or liability. Third option, both the above, and option 4, none of the above. Here the only first statement is the correct statement. The check must have been presented to the bank within the period of its validity or within 6 months from the date on which it was drawn, whichever is earlier. Now let us move on to question number 147. Director of a company is liable for an offence committed by the company under section 138 of NI Act. Option 1, because he is a director. Option 2, if he is a person in charge of and responsible to the company for conduct of business of the company. Option 3, if he is a director and shareholder with at least 5% shares, and option 4 if he is a resident of India. Here the correct answer is option second, if he is a person in charge of and responsible to the company for conduct of the business of the company. Section 138 of Negotiable Instrument Act is related to the dishonor of check. This is one of the important section in the Negotiable Instrument Act. Now let us move to question number 148. Is the statement of law correct? Implied authority of a partner in a partnership firm exists to selling of all properties of the partnership firm for the purpose of carrying on the business of the partnership firm? Options are yes, since a partner is an agent of all other partners, his action to sell any property of the firm for the purpose of running of the business of a firm is valid and result in transfer of ownership of the property which is transferred. This is not the correct answer. No, a partner has no implied authority to transfer any immovable property of a firm under the implied authority doctrine principles contained in section 19 subsection 2 clause G of the Indian Partnership Act. This is the correct option and also the right answer, because in the given option second is the right answer. Now let us move to question number 149. On the dissolution of a partnership firm, if the partner is the first person who will receive his share capital from the assets of the firm. Option first, yes, a partner's right in the assets of the firm is supreme and he is the first paid his share before making payment to anybody else, vide section 46 of the Partnership Act. This is the incorrect statement. Now let us see the statement second. No, a partner will receive his share capital from the partnership firm on dissolution, but first after the payments of the third party debts of the partnership firm, but before the debts of the partners payable to the partnership firm are paid. This is also the incorrect statement. Now let us move to statement number 3. Share capital of a partner in a partnership firm is paid only after paying the third party debts of the partnership firm and loans repayable to the partners by partnership firm. Yes, this is the correct statement. Statement third is the correct statement. First and foremost, the third party debts are to be paid, then the partners can share the remaining portions with to them. Question number 150. A suit of partnership firm to enforce any type of right of the partnership firm is not maintainable unless the partnership firm is registered under the section 69 of the Partnership Act before the filing of the suit. An unregistered firm cannot sue for any rights, be they contractual or statutory, unless the partnership firm is first registered. This is the incorrect statement. A partnership firm can sue for enforcement of its statutory rights even if the partnership firm is not registered. This is the correct answer. Option second is the correct answer.